Judgment in the appeal, Sharif against the London Borough of Camden.
The judgment in this case will be given by Lord Carnwath.
The Housing Act 1996 sets the duties of local housing authorities to provide accommodation for the homeless. The person is homeless if he has no accommodation, quotes, available for his occupation. Under section 176, accommodation is not regarded as available for a person's occupation unless it is, quote, available for occupation by him together with any other person who normally resides with him as a member of his family, or any other person who might reasonably be expected to reside with him. The accommodation provided by the authority must also be, quote, suitable. In 2004, the Council accepted that it owed a duty to provide accommodation to Ms. Sharif, the appellant, with her father, who is in his 60s and had health problems requiring her care, and also her younger sister, aged 14. After a period in a hostel and later in a 3-bedroom house, they were asked to move to 2 units on the same floor of a block of flats in North London, separated by only a few yards. She refused, saying that the accommodation was not suitable because her father's medical condition required them to live in the same unit. Following a review, the Council confirmed the offer on the basis that the problem of communication between the 2 flats would be no greater than in a house with 2 floors. On appeal to the County Court, Miss Sharif took a new point, which was that, as a matter of law, on the true construction of the section 176, the accommodation had to be in a single unit. That argument failed in the County Court, but succeeded in the Court of Appeal. They held that the words, quotes, together with, could not be satisfied by persons living in separate self-contained flats and not sharing any communal area. The Supreme Court, by a majority, allows the Council's appeal. Although one of the main purposes of the 1996 Act is to ensure that members of a homeless family are not split up, there is nothing to prevent a local housing authority offering accommodation in the form of 2 separate units, provided they are so located that they enable the family to live together in practical terms, and they are suitable for that purpose. Those are factual judgments to be made by the authority. The alternative view would produce surprising results. For example, the Council would not be able to improve the position of a homeless family living in an overcrowded flat by offering them an additional neighbouring unit of accommodation, even on a temporary basis. Nor is there any requirement under the Act for local housing authorities to provide communal living areas. This interpretation does not give local housing authorities a free hand. It must be applied reasonably and proportionately, and it is still a fundamental objective of the Act to ensure that families can live together in a true sense. Accommodation is not suitable unless that objective is achieved.
The Court will now adjourn.